But as a practitioner, as a solicitor of over 13 years experience, I do find that sometimes the Home Office immigration applications can be quite baffling. And I say that even as a practitioner, even with all my years of experience, I sometimes come across questions in the application form which do not necessarily make sense. So grammatically or otherwise, they seek to almost arguably confuse the reader of the form. And I find, and certainly my colleagues and our team members at the firm find that it's very difficult, very easy to make an error when completing an application form for the Home Office. Indeed, they do tend to be quite lengthy. They can be up to 57 to 60 pages in length. They can take a long time to complete, and you would need to know which box to fill in. So there are sections on the form where you need to know what category you're applying for, and it's important you get this correct. With regards to making an immigration application, there are fees that the Home Office charge. At the moment, on April 6, 2015, the fee was revised to £649 per person. So whether you're an adult or whether you have a dependent child or indeed any dependents, the Home Office, when making a discretionary leave to remain application, which as we've discussed briefly, is based on often human rights and suggesting that you have no ties to return to, then they will seek to obtain a fee from an applicant of £649, including an additional £649 per dependent. Now, I'd like to speak more about the paragraph that applies in immigration law with regards to overstay applications and what many of our overstayer clients tend to refer to. The immigration rule or paragraph is under 276 ADE of the immigration rules. That's paragraph 276 ADE of the immigration rules. Now, from memory, I believe subsection 6 states that where a person can prove that they have no social ties, assets, or indeed any connections to their home country, and they have been in the UK for less than 20 years, they can make an eligible application and request that they be granted discretionary leave to remain in the UK on their basis of having established a private life and maybe even a family life in the UK. Now, it's not always easy to show that you have no family or ties back in your home country. However, if you can show that you have stronger ties in the UK, then often it is plausible and possible to make an application for regularisation of legal status in the UK. Now, I think we are going to go to break now, so I will be happy to take any further calls after the break. Thank you for watching the Legal Hour, and I shall be back shortly.
From politics to economy, business, technology, the totality of what makes man is what we bring to you here on this sponge. We give you the information that you need. From business to economy to politics And that's what we do here on New Sponge, from the beginning to the end. And that is why we are here. Keep watching New Sponge from Ben Television. And today, I'll be your host.
Welcome back to this evening's Legal Hour with myself, Raheela Hussain, Principal Solicitor of Greenfields Solicitors. I'm a specialist immigration and human rights solicitor, and I would welcome your calls this evening on this evening's live call-in show. To tell you more about Greenfields Solicitors, we are a firm of immigration and human rights specialists based in North London. Our team deals only with UK immigration law, and myself, I have been practicing over 13 years, and I'm a senior solicitor who has written for a number of global immigration newspapers, such as the Afro News, the Filipino Express, the Punjab Express, and I currently write on a frequent basis for foreignerinuk.co.uk, where I author a monthly immigration column, where you can read more about the kind of work that we do, along with immigration articles to provide general and advice and informative information to members of the public who require UK immigration law and help. Now, this evening's show is centred on the subject of overstayers. Before the break, I tried to provide what I hope you will find to be useful information when applying for discretionary leave to remain or when seeking to make an application for variation of legal status to remain. One question I'm often asked by those who approach our firm is, how can I be sure, how can I be safe that I will be granted leave to remain in the UK? Well, each case is decided on a day-to-day basis and by its own individual merits. I'll go back to this question as soon as I take another call. Good evening, caller. How can I help?
Good evening.
Good evening, madam.
My name is Yemi.
Hello, Yemi.
I'm calling on behalf of my uncle.
Could you please speak up, Yemi?
Yes. Can you hear me properly now?
Just a little more would be great. Thank you, Yemi.
Okay. I'm calling on behalf of my uncle.
Yes.
Yeah. He's been here for over 7 years.
7 years, okay.
So.
Where is he from, Yemi?
He was in a relationship with a lady.
Right.
The lady's from, I think it's from Germany or something. So they've been together for over 2 years.
The lady's from Germany? Did you say the partner is from Germany?
Yeah.
Okay.
They've been together for over 2 years.
2 years. Do they live together at all, Yemi?
He wants him to relocate to Germany so that he can start a new life. But he said he preferred to be here.
Right, okay. And did you say they live together at all, Yemi?
Working. And they already made an application for him.
Right, okay.
He went to Germany and never came back. Though they do communicate over the phone, but at some point they couldn't communicate anymore.
I see, I see. So she doesn't actually live in the UK?
No, she has a family in the UK, but I think she's based in Germany. That's where she works.
And would it be correct to assume that your uncle has no legal status in the UK?
No, he doesn't have.
You see, I can give you an idea of how the law works under European law regulations, which are quite different from UK immigration law. Under EU regulations, where a person who has no lawful status in the UK, so somebody who's an illegal entrant or an overstayer or unlawful in the UK, gets involved with a member of the EU, so a partner from the EU, as you correctly say, Germany, and they have a relationship with that person, but the person needs to be based and settled in the UK. That's very, very important. So the EU national needs to be exercising something which is called exercising treaty rights in the UK. So if she was to live here, to work here, for a period of at least 3 months, then an application can be made to the Home Office. I appreciate from what you're saying that they've been in a relationship for 2 years, but the 2-year rule generally is where there's been cohabitation. So where your uncle and this lady would have lived together in the UK. Alternatively, if your uncle was to marry this lady, let's just say that the relationship is so serious now that they choose to marry, and she lived in the UK, then he could almost immediately make an application for something called a residence card. A residence card often gives a migrant 5 years to remain in the UK, being the family member of an EU national. Now, obviously, I don't know the exact specifications of your uncle's circumstances, so I'm just giving you some general information. But I would suggest that if he wants legal advice, then he can, of course, contact us at Greenfields Solicitors, and we could offer him more advice on his situation.
One more thing I forgot to mention. He already had a 3-year-old girl here with another mother.
I see. And is the child British, the 3-year-old daughter that he has?
No, I don't think the mother is British, no.
Does she have any legal status, the mother?
No.
Okay. Well, that could be difficult because that would mean that his daughter has no migrant status, no legal status. Okay, thank you for your call, Yemi. So going back to the issue of overstayers, it's extremely important to make an application, I say, to people as soon as possible. So don't delay years. Don't wait 5 years, 7 years, 10 years, 14 years. Don't hide. Don't be scared. Don't be fearful. Because fear itself is what often prevents people from trying to regulise themselves and sort out their legal lives quickly. I've had people who've attended my practice and they've waited 17 years when they could have applied for the same visa, after 10 years. And they've wasted all those years not feeling conducive to British society and not feeling that they're settled. We have another call, so I shall take that other call now. Good evening, caller.
Hello, good evening.
Good evening, sir.
Please, I would like to make an inquiry on behalf of myself.
Okay.
In 2005, June
Yes.
June 2005, I came into this country with a 6-month visit visa.
Sure.
Prior to that, I have presently overstayed my visa. But I was in a relationship where I have a child, that's a daughter.
Yes.
Our present age now is, and some few months, is going to be 6 in September 4.
Right, okay. Is your daughter British? Does she have any legal status?
Apparently, I think, in my previous relationship with my ex,
Yes.
he has a 2 years leave to remain. But on that basis, I don't know what I need to do because...
Do you see the child? Are you involved with the child at all?
I'm presently playing my role with the child.
You're playing?
I'm playing my role with the child in terms of visiting and also maybe buying her some few things.
Okay, and you said the child is going to be 6 in September, is that right?
She will be 6 in September as well.
Okay, there's a couple of issues with this particular situation that you've brought to my attention this evening. The first is that the child may not necessarily have British or indefinite leave to remain or any permanent lawful status in the UK. If that's the case and she's on some sort of temporary visa, then you can make an application and you should do so regardless of the situation with your daughter because you're somebody who's been unlawfully here since 2005, which is 10 years. It's a long time and you should consider making an application to obtain lawful status. You can obviously say to the Home Office, look, I've got this child, I believe that she has this level of lawful status, I'm involved with her, and you can argue parental rights and responsibilities and so forth. The other important point to mention here, just generally speaking, in immigration law, there is a law that says where a child has been in the UK for more than 7 years, so perhaps they've been born here or perhaps they've lived here for more than 7 years, then often people do seek to make an application for that child and their family members to obtain leave to remain in the UK on a discretionary leave to remain basis. If it can be shown that the child is very well integrated into British society, has been here for more than 7 years and there are undesirable factors that means that the child should not have to go back to its parents' native country of origin, then this is something that the Home Office will consider. Again, I would probably say to you, get some legal advice on your case. If you want to call Greenfields, we'd be happy to help you. Thank you, sir. Good evening, next caller. How can I help? I think we've lost that call. But do feel free to call in on Ben TV on 0208 808 0693 and you can speak to myself, Raheela Hussain of Greenfields Solicitors, a specialist in immigration and human rights, who would be happy to help and speak to you this evening with regards to any immigration problems that you have. So, we can speak about overstayers, legal visas, variation of visas all evening. It's, as I said earlier, a very, very huge topic. Another important factor that the last caller called in with was regards to he has a child in the UK, but he's not sure on whether his child has permanent lawful status in the UK. Perhaps his child here is also here without legal status, or maybe the child is on a temporary visa. The Home Office looks at each case, as I said earlier, on a case-to-case situation. So they will look at each individual case based on the exceptional, compassionate and compelling circumstances that a person can show to them on as to why they should be granted leave to remain in the UK. So the kind of things that constitute compelling, compassionate and exceptional circumstances include, for example, where a migrant has medical problems. Perhaps they can't return to their home country because they have an illness or medical conditions which makes it desirable for them to remain in the UK to obtain some level of medical treatment. That's not to say, certainly as I pointed out earlier this evening, that they should remain in the UK for free medical advice. I do believe we have another caller, so I will come back to this point right after the call. Good evening, caller.
Good evening. Good evening.
Good evening, caller. Okay, I think we've not been able to connect to that call, so I will continue. So the UK government here at the moment, and as is published in the news and what you'll see on a day-to-day basis, especially with the run-up to the election, is that they are not looking for people to come to the UK for economic migration reasons. That is something that Conservative government is very, very vehemently against, for people who wish to come to the UK to try and remain here to benefit or in some way economically gain from British society. So it's not to say that one should make an application in the UK because we have a better level of healthcare in the UK compared to maybe Nigeria or Ghana or Zimbabwe, India, Philippines, any other country in the world. No, the Home Office, what they will look at is often what kind of level of care can they get in their home country? What kind of level of care is available in the UK and what's comparable? I'll come back to this point as soon as I take, hopefully, the next call. Good evening, caller.
Hi, good evening.
Good evening, madam.
Yeah, I just want to find out who is for my cousin, yeah?
Yes?
Yeah, she got indefinite leave to remain
Yes.
in 2011,
Right.
and she applied for naturalization last year,
Okay.
and she was refused.
Okay.
After a year, the Home Office sent back a reply saying, based on a good character,
Yes.
so she's being refused.
Yes.
On the explanation on the good character, they said prior to the time she got her indefinite leave to remain,
Yes.
she was working.
Right.
That's why they classify it as a good character. So we are kind of confused because we really don't know why that should be based on the good character. Can you explain to me?
Yes, of course. So they said she was working prior to her obtaining the indefinite leave to remain?
Yes, she actually got her indefinite leave to remain under the 14 years.
I see. So there was a period of unlawful working.
Yeah.
Well, that's interesting. That's not something that is commonly used by the Secretary of State, because obviously one would assume the Secretary of State has granted lawful status and indefinite leave to remain on the basis of them being ultimately satisfied that she was of good character. On the application form for indefinite leave to remain, it does ask whether somebody has any convictions or if they've done anything criminal. Now, under the good character requirement of British nationality, that's quite different. This is regulated by the Rehabilitation of Offenders Act, if I remember, 1981 or 71 from memory. And what that looks into is whether the person has any criminal convictions. You know, have they gone to prison? Have they got any fines? Have they got any civil judgments? If they haven't, that is quite unusual. What I would suggest you do is, has she perhaps taken that letter for legal advice with the solicitor, because it can be challenged.
Yeah,
they do allow
actually
challenge.
She was going to challenge it.
Yes, it does usually allow an area of challenge, but the circumstances you describe are most unusual. And I would like to say to our viewers not to be deterred by what we've just heard from this particular caller, because it's something that's quite unusual, and I would suggest that your cousin gets legal advice to take this matter forward. Okay? Thank you, madam. So with regards to Well, it's an interesting topic. I mean, it goes on to the argument then of British nationality, and it's something that I should point out that where one applies for discretionary leave to remain for 2.5 years and they successfully obtain this, thereafter they can apply for indefinite leave to remain in the UK, either after 5 years or 10 years, depending on the route that they take. Thereafter, they are then eligible to apply for indefinite leave to remain. So either after 5 years or 10 years, they can apply for indefinite leave to remain. Thereafter, they can then make an application after some time for naturalisation as a British citizen. To become a British citizen, you will have to, under the current laws, show that you do satisfy the criteria. One, as our last caller identified, was the good character requirement. The Home Office are very particular at the present time, for good reason, that those who are applying for naturalisation as British citizens should have good character. So they should have no criminal convictions, they should not be a threat to public or British society, they should not have anything that suggests that by granting them the privilege, because indeed it is a privilege to hold a British passport, and this is globally recognised, that it would be something that would not be detrimental to British society. So it is possible through the discretionary leave to remain route, effectively then go on to apply for British nationality. Now, another topic that we can, during the few minutes that we have left remaining. Oh, good evening. I believe there's another call. Good evening, caller. How can I help?
Hello, good evening. Yeah, please, I'm just calling because I made an application and I was given a 2.5 years visa on discretionary leave to remain.
Good.
Yeah, why I'm actually calling because earlier on, you said something, you mentioned about the 5
So could you just please speak up for me?
earlier on, you mentioned about the 5 years rule and 10 years rule.
Yes.
Leave.
Yes.
Because I'm married to a British citizen and I actually have a British child.
Okay.
I was actually given a 10 years rule, which I don't understand why they give me that.
Yes. So when you made this application for discretionary leave to remain, when did you make this application, sir?
I made this application about I think 2 years last year.
Last year. Okay. Is it correct for me to assume that you're living with your partner and your child?
Yeah.
Okay. What is quite strange here, and it probably won't make much sense, is that where one is living with their partner, where they have a nice family life, where all is well, then the Home Office tend to give the 10-year route for settlement. What I can tell you in practice is those who have residence orders, contact orders, or where they're not living with that child but have access through a court document or access rights, as I earlier mentioned, without the need of going to court, they can apply for settlement usually after the 5-year route. I can't quite explain the logic to you because it would appear that one would need to apply for indefinite leave to remain quicker if they have a family life, but this is the way the Home Office have assessed the rules.
Yeah, that's why I don't understand why I was given the 10 years rule.
There's not much logic.
Yeah, so what do you think I can do then?
You can't do anything, sir. You have to extend the discretionary leave every 2.5 years and go through. As you know, you're lawfully here. You can live, you can work, you can study, you can be with your family. And ultimately, that should be something that you should be happy for. It may take you longer to get indefinite, but you are on the route. Okay, thank you, sir, for your call this evening. So, it's very interesting how the Home Office have assessed whether people are eligible for indefinite leave to remain under the 5-year or 10-year route. I don't have the application form in front of me now, but I do recall it does state on there that if you have access rights to British children or those who have lawful status, then you are eligible to apply usually under a 5-year route for settlement, whereas if, like the last caller stated, he was living in a happy family relationship, then there would be indefinite leave to remain after the 10-year route. It's not something that we can logicalise, but it's something that the Home Office have come to reason in their own viewpoint and what they feel is right. It's important to remember something. Discretionary leave to remain is discretionary leave to remain, and it's something that doesn't have to be granted immediately. It's not something that has to be granted. We have a call. I will take that call now. Good evening, caller.
Good evening.
Good evening. Hello.
I'm fine. I just want to make inquiries concerning myself.
Of course.
Okay. I've been here for the past 13 years,
Yes.
and I have a partner here who's having an indefinite to remain for the past 2 years. We've been together.
Right, okay.
Can I apply for any visa at all to stay in the country?
Okay, so your partner has indefinite and you wish to make an application?
Yes.
Okay, just to say, sir, I'm sorry to cut you, sir. We only have 1 minute left on air, so I'll just answer this as quickly as possible. Please try and obtain legal advice. You've been here for 13 years. You have a partner who's indefinite leave to remain. There's something under the immigration rules where if you can show there are insurmountable obstacles, then they can grant you discretionary leave to remain. I would like to confirm that all the information I've provided in the show is just information. It should not be relied upon as legal advice. And I thank you for tuning in to this evening's Legal Hour with myself, Raheela Hussain of Greenfields Solicitors. And I look forward to providing you again with useful information on UK immigration and human rights law. Thank you for watching.